Hello viewers, today's topic of discourse is revocation of offer, and in this lecture we will be discussing how revocation of offer is made, modes of revocation and the time of revocation. Communication of revocation to be effective must be from the offerer or his authorized agents. Now let's discuss first revocation of offer. Section 3 of the Indian Contract Act says that the communication of the revocation of proposals is deemed to be made by any act or omission of the party revoking by which he intends to communicate such revocation or which has the effect of communicating it. Second, communication of revocation when complete. According to Section 4 of the Contract Act, a communication as against the person who makes it, the communication of a revocation is complete when it is put into a course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it. As against the person to whom it is made, the communication of revocation is complete when it comes to his knowledge. For example, A revokes proposal by telegram. The revocation is complete as against A when the telegram is dispatched, and against B it is complete when he receives the telegram. Now let's discuss about when can proposal be revoked. According to Section 5, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer but not afterwards. For example, A proposes by letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post. A may revoke his proposal at any time before or at any moment when B posts his letter of acceptance but not afterwards. In case of an auction, it has been held in Payne versus Cave that the bidder is entitled to revoke his bid at any time before the fall of the hammer or before the property is finally knocked down. Now let's discuss the valid modes of revocation of offer. A proposal is revoked by the communication of notice of revocation by the proposer to other party. Second, by the lapse of time prescribed in such proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without communication of the acceptance. Third, by the failure of acceptor to fulfill condition precedent to acceptance. Fourth, by the death or insanity of the proposer when the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. Now, what does by notice of revocation mean? An offer becomes contract when it is accepted. Before it has been accepted, it creates no legal obligation and therefore it may be revoked at any time before it is accepted. This can be illustrated as on April 10, 1990, A offered B to sell his car for 60,000 rupees. B was asked to signify his acceptance by April 18, 1990. On April 12, 1990, A sold his car to C for 70,000 rupees. This he did without revoking his offer to B. However, B came to know of this fact through his resources on April 14, 1990. Still, he signified his acceptance to the offer on April 16, 1990. Has this resulted into a binding contract between A and B? It was true that on April 14, 1990, B came to know of the sale of car to C, and thus A was not willing to sell his car to him. Under English law, there can be no binding contract under these circumstances, but under Indian law, the rule is different. Under Section 6(1) of the Contract Act, a proposal is revoked by the communication of notice by the proposer to the other party. Since the notice of revocation was not communicated by A to B, the offer was not revoked. Hence, the acceptance by B was valid, and such there was a binding contract between A and B. Thus, to be effective, the notice of revocation has to be communicated by the proposer or his agent and not by anybody else. On this point, English law is different from Indian law. In India, notice of revocation has to be communicated by the proposer only, whereas in England, the offer stands revoked, even though the offeree comes to know about the revocation of offer through some other source and not by notice by the offerer himself. Second mode of revocation is by lapse of time. A proposal is revoked by the lapse of time prescribed in such proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without communication of the acceptance. This was also held in Jaya Mahal Corporation Housing Society Limited versus MS Zenith Chemical Works Limited, AIR 1991. What is reasonable time will depend upon the fact and circumstance of each case. For instance, where the subject matter of the contract is an article like gold, the price of which rapidly fluctuates in the market, very short period will be regarded as reasonable, but not so in reference to land. Sometimes the parties may expressly fix the time up to which the offer will remain open. For example, it may be stated that the offer is open till 15 January 5 p.m. Such an offer lapses automatically if it remains unaccepted till the stipulated time, and the same cannot be accepted further thereafter. Even if no time has been prescribed within which the acceptance can be made, the offer stands revoked on the lapse of a reasonable time. Non-acceptance within reasonable time means an implied refusal by the offeree to accept the offer. Third, by the failure to fulfill a condition precedent. Where the offer is subject to a condition precedent, it lapses if it is accepted without fulfilling the condition. Where a salt lake was offered by way of lease on deposit of a sum of money within a specified period, and the intended lessee did not deposit the amount for 3 long years, it was held that this entailed cancellation of the allotment held in the state of West Bengal versus Mahendra Chandra Das 1990. Fourth mode of revocation is by the death or insanity of the offerer. An offer also lapses on the death or insanity of the offerer. Ansons explains it as the death of either party before acceptance may cause an offer to lapse. It would seem that, in principle, an offeree cannot accept after he is informed of the death of the offerer. An acceptance communicated to the offerer's personal representatives will not bind them, unless the offer is one which could not have been revoked by the offerer during his lifetime. Held in Errington versus Errington 1952. But the position is not clear under English law, where the offeree accepts without knowing the fact of death of the offerer. In India, however, the position is quite clear that an offer lapses by the death or insanity of the offerer only if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance, Section 6(4) of the Contract Act. Now let's discuss time of revocation. An offer can be revoked at any time before the communication of acceptance is posted, but not afterwards. After the Payne versus Cave 1789, it has now been established that revocation is possible and effective at any time before acceptance, and till that moment no legal obligation exists. In Baroda Oil Cakes Traders versus Prashottam Narayan Das Bagolia, Gajendra Gatkar J. of the Bombay High Court held as under. But so far as the making of the contract is concerned, the proposer is bound as soon as the acceptance is posted and subject to the right to the acceptor to revoke his acceptance. The contract is complete as soon as the acceptance is posted. Now we will discuss why communication of revocation must be from the offerer or his authorized agents. A communication of revocation must be from offerer of his authorized agent. In England, however, a different rule has been laid down. In Dickinson v. Dodds, it has been held that it will suffice if the offeree comes to know that the offer has been withdrawn. In this case, the defendant offered to sell a certain property at a certain price to plaintiff, requiring the plaintiff to accept the offer until Friday 9 am 12th June. A day before the lapse of the said time, the plaintiff came to know through a third person that the property in question had already been sold to some other person. Despite this, the plaintiff before 9 am of 12th June handed over to the defendant a notice of acceptance and sued the defendant for specific performance of the contract. The court held that a sale to third person was an effectual withdrawal of the offer. The plaintiff knew the Dodds was no longer interested to sell the property to him as plainly and clearly as if Dodds has told him in so many words, "I withdraw the offer." It is to my mind quite clear that before there was any attempt at acceptance by the plaintiff, he was perfectly well aware that Dodds had changed his mind and that he had in fact agreed to sell the property to Allen. It is impossible therefore to say there was ever that existence of the same mind between the two parties, which is essential in point of law at the making of an agreement. Mellish L.J. also observed, just as when a man who has made an offer dies before it is accepted, it is impossible that it can be accepted. So, when the person to whom the offer was made knew that the property has been sold to someone else, it is too late for him to accept the offer, and on that ground I am clearly of the opinion that there was no binding contract for sale of this property by Dodds to Dickinson. But as pointed out by Pollock and Muller, the reason given for the decision in Dickinson v. Dodds have been freely criticized in England, but as the decision itself is not of positive authority in India, in a matter covered by the terms of the Contract Act. Thus, the rule laid down in Dickinson v. Dodds is not applicable in India. It may be noted that Section 6(1) provides, "A proposal is revoked by the communication of notice of revocation by the proposer to other party." In accordance with this provision, it is clear that in India, the notice of revocation must be given by the proposer himself. A notice by a third person will not suffice. Now let's discuss distinction between offer and invitation. An offer and invitation to offer are not one and the same. The difference between the two must be appreciated. An offer is definite. It is an intention towards a contract. An invitation to offer is an act precedent to making an offer. It is done with intent to generally to induce and negotiate. An invitation to offer gives rise to an offer due negotiate. It is not capable of being accepted. In an invitation to offer, there is no expression of willingness by the offerer to be bound by his offer. It is only a proposal of certain terms on which he is willing to negotiate. It is not capable of being accepted as it is. When there is an advertisement by a person, he has a stock of books for sale. It is an invitation to offer and not an offer. This advertisement is made to receive offer and to further negotiate. In terms of Section 2A of the Act, it is very clear that an offer is the final expression of willingness by the offerer to be bound by the offer if it is accepted by the other party. Hence, the only thing that is required is the willingness of the offeree to abide by the terms of offer. The test to decide whether a statement is an offer or invitation to offer is to see the intention. If a person who makes the statement has the intention to be bound by it as soon as the other accepts, he is making an offer. Thus, the intention to be bound is the important thing, which is to be seen. In Harvey versus Facey, Privy Council succinctly explained the distinction between an offer and an invitation to offer. In the given case, the plaintiff, through a telegram, asked the defendants two questions, namely, will you sell us bumper hall pen and telegraph lowest cash price? The defendants replied through telegram that the lowest price for the bumper hall pen is £900. The plaintiff sent another telegram stating, we agree to buy bumper hall pen at £900. However, the defendants refused to sell the property at the price. The plaintiff sued the defendant, contending that they had made an offer to sell the property at £900 and therefore they are bound by the offer. However, the Privy Council did not agree with the plaintiff on the ground that while plaintiffs asked two questions, the defendant replied only second question by quoting the price, but did not answer the first question, but reserved their answer with regard to their willingness to sell. Thus, they made no offer at all. Their lordships held that the mere statement of the lowest price at which the vendor would sell contained no implied contract to sell to the person who has inquired about the price. The above decision was followed in Macpherson versus Appanna. The plaintiff offered to purchase a lodge owned by the defendants for ₹6,000. He wrote the defendant agent asking whether his offer had been accepted and saying that he was prepared to accept any higher price if found reasonable. The agent replied, won't accept less than ₹10,000. The plaintiff accepted this and brought a suit for specific performance. It was held that the defendant did not make any offer or counter-offer in his letter, but was merely inviting offers. There was no assent to the plaintiff's offer to buy at ₹10,000 and therefore no concluded contract. So that was all for today. Hope you have understood all about revocation of offer. We'll see you soon with a new topic. Till then, take care of yourself. Goodbye.